Okay, we are all now back on the record on Highland and Ballard. So, Mr. Brown, you've had full opportunity to speak to Mr. Highland?
Yes.
All right, I've been adjourning this pretrial for your benefit, Mr. Highland, because your unit was in quarantine, and I'm glad to see that that's finally over. The court has received a petition seeking a goal change, and I'm assuming the agency is indeed still seeking a goal change. Is that correct, Mr. Way?
It is, Your Honor. I think we might have some updated information for the court. It's been a while since the court report was submitted.
Well, let's do that. Ms. Cooling, do you have additional information for the court?
I do, Your Honor. As Mr. Way said, we still are requesting a goal change at this time. Also, I wanted to ask the courts to order that DHS be able to have communication with Ms. Patrick's probation officer. There was a recent policy change, and we are now required to have a release sign to be able to communicate with probation officers. Prior, this was not a policy. The agency itself has asked Ms. Patrick to sign a release of information for DHS to communicate with her probation officer, and she has not signed that at this time. So we are asking that it be court ordered that DHS be able to communicate with her probation officer moving forward.
And
Mr. Kelly, do you wish to speak to that?
Your Honor, I'd like to speak to the goal change. If you want me to address that specific issue, I can. We didn't really do anything with the testimony of Mr. Hampton either. So there's like three things sitting out there. How would the court like to address those and in what order?
I only ask you because I just heard about it from Ms. Cooling. So the order isn't all that important to me. If you want to address the goal change first, go right ahead.
If Odyssey House, if you could provide an update to the court on Danielle's progress and any screens that she's taken, because we have, as the court has said, adjourned this a number of times. They're muted, Your Honor.
Sorry, Your Honor. At this time, Danielle has remained completely abstinent from all substances, and her drug screens reflect this. She is randomly screened once a week. As for her progress in treatment, she has been participating in all of the staff-led clinical groups, as well as in the therapy once a week with me. Additionally, she has done homework and been working on relapse prevention. And she's doing well overall, remains committed to her recovery and sobriety, and making very healthy plans for transitioning eventually into the community. So she's doing exceptional. She's also participated in what we call a pro, and has been promoted to a level 1, where she has been doing very well, working on her attitudes, actions, and behavior, which is the goal focus of level 1.
How long has she been in the program?
Danielle entered residential treatment on January the 2nd, but that was after being in detox. So she's been at our facility since December 29th of 2020.
Okay. Judge, you had a question?
Yes, could you state your name, please? I want to make sure it's clear on the record.
Yes, Your Honor. My name is Jessica Hammond.
Thank you.
And you had indicated there was some transitioning she was going to be doing. What transition was she going to be making? Was it to leave the program? Was she going to stay there? What was it?
At this time, Danielle remains committed to remaining in residential treatment. However, it is an aspect of our program and of our therapy that we discuss healthy boundaries, goals for after treatment. What does it look like for the future? It's really part of getting kind of an idea of like relapse prevention services in the community and that kind of stuff. But at this time, she remains committed to being in residential treatment.
Okay. Just to go off a little bit, you had heard Mr. Hampton's testimony regarding his involvement with Garrett and mom's involvement, or how she would fit into that equation. And I brought up the question of, has he had contact with you, or contact with you would be beneficial. Had you made a request of this caseworker to have contact with Mr. Hampton? And if so, what was her response?
Yes, I did. On February the 9th, so following court on February 2nd of this year, we had discussed whether or not it would be beneficial for Danielle to participate in family therapy with Garrett and Steve in order to facilitate contact. Of the following week, on the 9th of February, I did request his contact information so I could coordinate with Steve in order to facilitate family therapy if that would be beneficial. The response I got that day from Ms. Cooling was that she had spoken with Steve and that Steve had stated that the family therapy was not beneficial and that no contact would remain. And I was not given any information in regards to how to contact him.
Okay. With that update, Your Honor, I think the court needs to keep in mind it wasn't that long ago that these children were home and we were about to close the case out, and mom did relapse. She owns it, and she didn't hide from it. She's taken the steps to get into her sobriety and into her recovery. I understand this case has been open for an extended period of time. However, she's doing real well. She has a strong bond with her children. And in Garrett in particular, I find it disturbing that we have a parent agency treatment plan dated January 20th of 21, where it indicates in there that Garrett's bond with his mother is very strong. And that also in regards to his acting out behaviors, in that same report, it indicates his behaviors were due to his lack of contact with his mother, and also concerns of him competing for attention with his siblings in his new placement, which has caused him to be short-tempered. So we're throwing a lot of blame and shifting blame onto mom. Her part in this is undeniable. She relapsed. We understand that. However, the steps she's taken since then, I think the court has heard. This has not been a couple of weeks. This has been going on 3 months now that she's been in this program and has been 100% compliant with it, and is doing very well. It's undeniable her bond with her children and the relationship she has with them. I don't think it's appropriate at this time to change the goal simply because this case has been open for an extended period of time. We've had other cases that have been open longer that have ultimately resulted in either reunification or return home of the children, or another alternative that had to be looked at because the parent wasn't doing well. I think the testimony you would hear at any trial is going to be supportive of the fact that she is sober and taking the appropriate steps and has a transition plan in mind where she's not coming back to Jackson, where she understands that's where the triggers and the bad influences would be, which caused her to relapse in the first place. I would request of Your Honor to deny or not accept the petition for filing or setting it for hearing. And if the court feels it's appropriate, set this matter back on the schedule for reunification purposes and have a shorter review period for this court to keep an eye on what things are happening or not happening. 45 days instead of 90s probably makes more sense. So if you have any type of mishaps, it can be immediately addressed. She understands the gravity of the situation. She's putting her best foot forward, and I think she's doing, as her worker there indicates, an exceptional job. These children are undeniably bonded with their mother. For this court to entertain a petition at this time, I think it's premature considering where she is at in the program. So I'd request of the court to simply deny that at this point in time and continue this on the reunification track as taking into consideration what her progress has been so far and what you're going to likely hear at the termination trial.
So before I hear a response from Mr. Way or the LGAL's viewpoint on this, I want to give Mr. Brown an opportunity.
Obviously, Judge, my client agrees with Mr. Kelly. His parental rights rise or fall with regard to how Miss Patrick's doing, considering his predicament right now. He will be out probably in less than a year. So he would be in agreement that this case be continued towards the reunification track. Further, I would ask the guardian if the guardian would inquire of the placement, if Mr. Hyland could have their address so he could write them a letter. He would like, not to the kids, but he would, because they're too young, but would just like to write a letter to the grandparents. And if that could be provided to me so I could forward it on to Mr. Hyland, that would be appreciated. Thank you.
So, Mr. Way, assuming you'd like an opportunity to respond to both counsel.
I would, Your Honor. You know, the problem that I have with Mr. Kelly's argument, and I guess Miss Patrick's stay at the Odyssey House is, number one, you know, she's not court ordered to be there. And what's kind of left out, yeah, she doesn't want to come to Jackson. Maybe she won't willingly come to Jackson, but she has a bench warrant out for her arrest, for a probation violation, for the conduct that kind of led to the court's re-removal of these children. I have talked to her probation officer. I'm not under any sort of DHHS policy obligation. What I can tell you, the court, based on my conversation with Ms. Yeomans, is that she fully intends on following through with that probation violation. She fully intends on asking that that the mother's probation is revoked, that she's sentenced to a jail term. And a large part of that is because that there's been several instances in her probation where this sort of thing has happened. There's been some sort of relapse, some sort of missed drug screen, something like that. And every time that happens, the mother checks herself into rehab and kind of ignores probation and everyone else. There's a clear pattern there from what I'm told. We've seen this sort of thing. The court's heard or seen a lot of these cases where we have these relapses so late in the game. And I think that we need to see an extensive amount of sobriety before we can even consider return home, given how this case is going. And at this point, it's just not fair to the kids. These kids need permanency. They deserve permanency. And so we're asking that the court adopt the goal change. Thank you.
Mr. Hotchkiss?
Thank you, Your Honor. I agree wholeheartedly with what Mr. Way said with respect to the mother, so I won't belabor that point except to say that I was given to understand that she was facing approximately 11 months on that probation violation claim. It's also my understanding that's the reason she's not come back here. So I would be in support of the agency's request that she sign a release so that we can have more information about what she'd be facing if she does come back to Jackson. But I think it's obvious why she has no intent to come back. As it relates to these three kids, they've been in care over 2 years, with the exception of the short time they were with their mother. They're with their grandparents. They are extremely bonded to their grandparents. They're into a routine in their grandparents' home. I think it is disruptive to continue this case for them. What we heard from Mr. Hampton, I think speaks volumes as to how it affects these kids. And it really doesn't make any difference from the kid's perspective as to whether mom's doing well now or she's not doing well now. In fact, I would argue it's probably harmful to keep them apprised of that just because of her instability. And I think that would make foster some false hope for Garrett and the other children if they were to be kept apprised of that. They know the environment where they live now. They know what their relationship is with their grandparents, and they really do need some stability. And I get that she's been there 2.5 months and she's doing well now, but we've been down this road before with a couple of years. So it isn't a matter of her just, doing another month or two transitioning out and everything's going to be okay. I don't have any confidence at all that that's going to be the case. And then she still has the other legal problems to deal with. I thought what Mr. Hampton testified today not only speaks for Garrett, but also could be considered with the other 2 children, even though he's the oldest and probably acting out the most. But I think that permanence is what these children need. I'm in support of a goal change, and I would ask that the court order that. Thank you.
Mr. Hodges, respond to my request.
I'd be happy to discuss that with the placement, Mr. Brown, and let you know what our thoughts about that.
Thank you.
Your Honor, briefly in response in relation to the bench warrant issue, she has been attempting to get that resolved over the past month or so. Ms. Yeomans is not willing to talk with her about it. She has attempted to contact Judge McBain to get that taken care of. They were told that she would essentially have to contact her attorney, but then when she tries to find out who her attorney is, she says, "Oh, you don't have an attorney anymore." So it's not something that she's pushing off or hiding from. She's actively trying to address it. And to be frank with you, what Ms. Yeomans wants isn't the be all end all. Judge McBain can decide for himself what's ultimately going to end up happening. And this stability and permanence argument, you hear it in every single case, Your Honor. The children are so young, they're not crying out for permanence or stability. They're with family at this point. So I don't see the harm in this matter being continued on the reunification track, considering the progress that she is currently making, Your Honor. Thank you.
Okay, thank you. So Mr. Brown and Mr. Kelly both make some great arguments that the court would certainly consider in contrast to whatever might be presented by the petitioner at a termination hearing. Certainly based primarily on the amount of time these children have been in care. The court is going to order a goal change, and you can present your arguments at a termination hearing. So we need a date for the court will receive a termination petition on April 6th at 9 a.m. I will set a termination hearing at that time. I am going to order that the agency be allowed to speak with the mother's probation officer, and we will set, and I'm certainly, I'm not going to order any parenting time as to Garrett, based on what I've heard today. That wouldn't be good for him, at least at this point. I am going to set a review hearing in the event I do not terminate, and that will be June 15th at 8:45. And as I said, we'll set a termination trial date on April 6th.
Thank you.
Is there anything that the court has failed to address?
Oh, Your Honor, thank you.
Thank you, Your Honor.
Thank you. So I think we're ready now to do some releases. I'm going to turn off the live stream.
We do have a 10:30 is just a really quick, like 1 minute trial.
Oh, okay. Well, why don't we do that first then, while I've got the live stream going? This is the file.
This one is? We have to stage it.
Okay, so this is the matter of Love Neal. And let me make sure I've got everyone here. We'll let Ms. McCluskey in, although I don't think she's on this file. And I don't know who represents whom in this file. Obviously, Mr. Way for the petitioner. Ms. Samantha Wright is here on behalf of the agency. And let's see.
Ms. McCluskey's GL.
LGAL. And do we have any other appointed attorney in the file?
No, Your Honor, the mother's rights have previously been terminated and the father has never appeared.
Okay, go ahead.
Your Honor, I would call Ms. Wright.
Ms. Wright, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Samantha Lynn Wright.
Go ahead, Mr. Way.
Thank you, Your Honor. Ms. Wright, you filed the supplemental petition in this case, is that correct?
Yes.
And you are the assigned foster care worker for Love Neal.
Yes.
The mother's rights have previously been terminated, is that correct?
Yes.
And the legal father is Charlie Miller, date of birth 10/17/1973.
Yes.
Mr. Miller was adjudicated as to back in I think November of 2020. Does that sound about right?
Yeah.
Okay. And at the time, he basically was avoiding the CPS investigator, did not want to be part of Love's life. Is that correct?
Yes.
Have you made attempts to contact Mr. Miller to get him engaged with services and to get him engaged in Love's life?
Yes.
What attempts have you made?
I have called. I have sent letters. I did Facebook searches. I actually spoke with his mother at one point, and she said that even she's unable to make contact with him unless he just shows up.
What's your understanding of where Mr. Miller is currently?
My understanding is that he is currently homeless in Florida, and he doesn't have a job or anything, and he's very unstable.
Where is Love currently placed?
In a foster home, a licensed foster home.
Do you have any concerns for that home?
None whatsoever. And she's actually placed with her half brother as well.
Okay, that's Ms. Crabtree's, one of Ms. Crabtree's other children who've been terminated on?
Yes.
Okay. Is Love bonded to her foster placement?
Oh, very much so.
Are they willing to adopt?
Yes.
Do you believe it's in the best interests for this court to terminate Mr. Miller's parental rights to Love?
I do.
And why do you believe that?
I believe that if she were placed with him, it would not be a very safe or stable situation. And she is in a home that's very loving, and she's bonded with the family very well. And she's with her brother, and they take very good care of her.
Is it fair to say that even if Mr. Miller showed up tomorrow, that it would take about a year or so just to get to a point of reunification, given how little we know about him?
At least, yes.
Thank you. I have nothing further, Your Honor.
Any questions, Ms. McCluskey?
No, Your Honor. Thank you.
Any further presentation, Mr. Way?
No, Your Honor.
Can we dispense with arguments?
Yes, Your Honor.
It's clear based upon the testimony that Mr. Miller is indeed the legal father of this child and has had virtually nothing to do with this child since his birth. He has failed to participate in any proceedings regarding the child. He has failed to seek custody. Grounds for termination exist on a number of bases. Without regard to intent, he's failed to provide proper care and custody. There's no reasonable expectation he will be able to do so within a reasonable period of time, given the child's age. He's been responded in a proceeding. 182 days or more have elapsed since the issuance of a dispositional order. Conditions that led to adjudication continue to exist. There's no reasonable likelihood they'll be rectified in a reasonable period of time. And he has effectively deserted this child for a period of 91 days or more. He has not sought custody during that period. The court also finds that termination is in the best interest of the child. He's in a loving foster home that's able and willing to provide permanency. There's no reasonable likelihood. In fact, there's no expectation whatsoever that his father is ever going to step up and provide this child with the permanency that he deserves. So the court finds termination is in his best interest. I'm going to terminate the father's parental rights, and we will schedule a post-term hearing for April 20th at 8:45. Thank you.
Thank you.
Thank you.
And now I think we are ready for our release hearing. So I'm going to